24 minutes onto the hour of 8 o'clock. We're glad you're still with us here on Morning at NTV. We are taking note of using succession processes to protect property rights as the discussion underway right now. For those that are just joining us as I speak, my guests this morning are the President of the Uganda Law Society, Bernard Oundo. Is it allowed to say Your Excellency?
Let me think about it.
And Charles Kasibayo, the Administrator General, will be talking exclusively about succession processes to protecting property rights, especially the will, as in will. Let me first begin with the Pro Bono Day that has been earmarked as an event that will that underscores, in terms of the theme, understanding succession processes as a means of protecting property rights and ending family conflicts. Now, there's an introduction of a word that takes me back, family conflicts, but that will come later. Tell us about the Pro Bono Week and Day. What is this all about?
Good morning to the viewers, and Chris, thank you for hosting me this morning again.
You're most welcome.
The Uganda Law Society has a number of mandates. One of them, of course, is advancing the cause of rule of law and good governance. The other, of course, is building the professional capacity of its members.
That's right.
But it also has a public mandate. And the public mandate is ensuring access to justice. Now, through that mandate of ensuring access to justice, the Uganda Law Society has been conducting a Pro Bono Day for the last 13 years.
Okay.
And in this Pro Bono Day, lawyers, we are now about 4,300 lawyers in this country, in the different towns, Kampala, Jinja, Mbale, go out to offer free legal services. So we go out to offer free legal services. We call the public to come at our different venues and offer free legal services. So the Pro Bono Day is done for that purpose of ensuring that as members of the Uganda Law Society, we are not just looking at ourselves and looking inwardly. We are also looking to add value to the public. And so we do it through what we call the Pro Bono Day. So this year's Pro Bono Day is on Friday, which is tomorrow.
Which is tomorrow.
1st September. For the people in Central Region, it's going to be at the railway grounds. Okay. So we are calling the members of the public to come and receive free legal services on this Pro Bono Day.
Just allow me seek a little bit more clarity on free legal services. If the Pro Bono Day is a 12-hour engagement or initiative, and then the Pro Bono Week is a 5-day or 6-day engagement, the court processes within the justice system take far longer than that time. Does that mean somebody who has accessed Pro Bono services during that time is or gets that the service in a continuous manner for as long as a particular case goes on?
Yes. Thank you for that question, Chris. So during the Pro Bono Day, we are going to register some of these issues. And then we're going to hand them over to lawyers.
Okay.
In terms of numbers, we have 1,870 lawyers providing free Pro Bono services. So you will come, we will listen to your issue, and if we have to go through the court process, we register you.
Okay.
And as Uganda Law Society, we now take the case and offer free legal services from the time you have come up to the time of its conclusion in court. Yes.
All right. Okay, in line with the theme of this year, understanding succession processes as a means to protect property rights and end family conflicts. What informed the choice of this particular direction?
So we have looked at the number of cases that we are giving advice on a pro bono basis. The biggest number of cases are coming from land rights.
Yeah.
The second biggest number of cases are coming from family conflicts. But you see, family conflicts are also related to land. There's that close relation between family conflicts and
land is always a trigger.
Yes, and therefore we thought that in order for us perhaps to reduce the number of conflicts that are coming through, we need to sensitize. Because if you sensitize the public, then people know what to do. And if they know what to do, then you reduce the number of cases that are coming. But it also helps the justice sector, because these conflicts are coming in, you then have a number of cases filed at the family court.
That's right.
And therefore, if we sensitize, for instance, we are going to sensitize on wills, and the Administrator General is here. We're going to sensitize on the laws of succession and the laws governing succession. We believe that by doing this, we shall be able to reduce on the backlog, but also reduce on the number of cases that are being filed.
Okay.
So it is informed by the numbers that we have.
Okay, we're glad we have the Administrator General with us this morning. Mr. Charles Kasibayo, when I hear the words succession planning and property rights, President has ably put it that it is a problem across the country, and we do here in other places across the world. Just take us through the status quo when it comes to the word will within the justice system in Uganda, before we can even go into the nitty-gritty of when and how it is supposed to be. Is it dispensed or consulted in order to ensure who gets what and how things go or move forward?
Thank you, and good morning to our viewers. Going to that big subject of a will.
Just compress it for us quickly. And
it's provided for under the succession law.
Yeah.
And it has recently been amended and took effect on 31st May 2022.
Wow.
A will is a testamentary disposition of the will maker's bequests, or what he gives to the intended beneficiaries. Basically, we have statutory requirements to it, that it should be signed on each page by the one who makes it, the will maker or a testator, and at least 2 witnesses. They should put their signatures, their names and addresses on each page of the will. And it should name executors who will implement it. Non-naming of the executors does not invalidate it. Actually, it brings in the aspects of the Administrator General to vet applicants that will implement it. But basically, when a will is properly made, it greatly reduces conflicts, because largely the source of conflicts in family matters is on identifying beneficiaries. But once the testator has clearly named the intended beneficiaries, then that dispute, which is largely highly litigated on, will be minimized. And another issue is usually who administers the estate of the deceased person, the administrators. So once the testator or the will maker has clearly named the people who will implement the will, then that area of conflict is minimized, because it's also largely litigated on, objecting on who will administer the estate of the deceased person.
Okay.
So we encourage people to make wills so that conflicts are largely minimized. Thank you.
All right, I'll be returning to you shortly so that you can offer more perspective when there is no will. Let me first concentrate on when there is a will and return to Bernard Owundo. Many times the contestations have been around the fact that perhaps somebody wrote the will without their will or understanding, that is it sanity, something like that, or they could have been coerced, for example, by one party or the other. When such happens, how do the lawyers come about to ensure that at the end of it all, the will stands or whatever is contested is addressed?
So, Chris, the first point, and just to supplement what the Administrator General was saying, is that there are legal requirements that you're required to fulfill for you to be able to make a will.
That's right.
So that it is a valid will. Because if you don't fulfill those requirements, it will not be a valid will. And one of those requirements is that, first of all, the person making the will must be of sound mind. In other words, you must be conscious of what you are doing. If you decide to go maybe to a bar and first take a few beers or drinks and then come back and make a will, you may be taken not to have been of a sound mind at the point at which you are making the will. If you there's what we call also insanity, and sometimes you could have some of these cases. You can't make a will in that state of mind. So you're supposed to make a will when you're conscious, understanding what you are doing. That's number one. Number two, the will must be made by someone who is above 18 years.
Okay.
So a child cannot make a will.
Even if a 17-year-old has a child, they should not make a will.
You must be above 18 years.
Okay.
3, you must not be coerced. There must not be someone coercing you to be able to make a will. Because what that coercion does, that then it takes away the fact that you knew what you're doing, that there was some certain influence.
That's right.
that was making you to be able to do the will. Okay. Fourthly, it must be in writing. So the general rule is that a will must be in writing, except for wills which are called privileged wills. So privileged wills are wills which are made by members of the armed forces. Those are what we call privileged wills.
Why members of the armed forces?
Because of their nature of work.
You can't write
you don't have time to write
under the sound of fire.
Yes, you don't have time to write.
Interesting.
Yes. Okay. So that is the major issue. So if you don't fulfill those requirements, then your will be contested. And if it is contested, then it will not be held to be a valid will.
Okay.
Yes.
There's something interesting there, but allow me tackle the aspect of absence of a will. What happens when there is no will, or either there is a tendency, for example, among Africans to think that death is a little bit still far away. I will do it at a certain point in time, but then again it strikes and there isn't a will. What do we do at that point, Mr. Charles Kasibayo?
Thank you. Maybe to add on the presidency matter of UPDF or soldiers, that exception is given to them only when they are at the battlefield.
Only at the battlefield,
They shouldn't take it that they can write a privileged will
because they are soldiers.
Not of the deployment, but when they are at war.
So at that point, who helps the enforcers that this guy said this and this?
The ones
the
who
commander
are present.
Or
actually it can even be oral and say I give this property so and so, as long as somebody say I was present during the firing.
During the fire.
That would be enforced. But outside that,
it's a complicated scenario.
The will as ably articulated by the president.
Okay.
So when a person dies without leaving a will, the law requires that a report is made to the Office of Administrator General. We have different offices We have our head office is here at George Street, Georgian House. We have an office in Imbarara, Fort Portal, Arua, Guru, Soroti, Mbare, and Moroto. We have 7 region offices. So a report can be made to any of those offices of the Office of Administrator General, naming the properties of the deceased persons, and then the core mandate of the Office of Administrator General is to vet these applicants for what we call a certificate of no objection. We do so through our agents, who are the chief administrative officers. They conduct meetings, return reports, and we vet, engage the family to make preference for the choices, but we give it an element of the law, preference for the spouses, and a certificate of no objection is issued, which is a requirement for them to go to court and apply for letters of administration. But in that interim process, there are issues of ensuring that the estate is not wasted, it's not intermeddled with. So we ensure that there's that protection, and people who are stealing or intermediating with the estates, they are different offenses prescribed under both the Administrator General's Act and the Succession Act to face the law. Basically, that is the core of our duties. But even when there are severe disputes that the family cannot agree, then the office applies for letters of administration and distributes the estate of the deceased person.
Based on their understanding of the realities on the ground.
Yes, based on the provisions of the law, because the law gives the percentages of sharing that estate.
Oh, maybe that attempts to answer what was going to be my next question about fairness.
Yes.
There is a tendency, for example, of favoritism, where somebody thinks that one person ought to get more than the other, when the entire family or even the greater clan agrees that perhaps the person who has been unfairly treated deserves a little bit more. That is arbitration. Okay? All right. And then we've had people who say, I'm not going to leave my son with anything. Let him do his own. Me, I did my part. Let also him do what? When a person leaves a will like that and it is contested by the would-be beneficiary who has not gotten anything, does the law help them? Or it will agree entirely with the fact that the will is legal? Is that a question can be answered by you?
Yes,
okay.
Thank you. It is a different scenario, of course, when the person dies without a will. But once a person has left a will, a valid will, as everybody explained,
it doesn't matter whether it's unfair to you.
It doesn't matter, because there is an element of what they call testamentary discretion. To give a discretion, freedom to give out the property. The new amendment has provided for some checks, and that checks in regard to the residential holdings, the homes. Those are not subject to distribution. And also protected the spouse. You have to leave, provide for the spouse and the dependent children. These who are wholly dependent on you in terms of the minor, if they are below the age of maturity, you have a statutory requirement to provide, because they are dependent on you. But for me and you, Chris, and Mr. President, the testator can ably leave us out. There's no statutory requirement.
I should stop putting on suits.
They must
it could give the wrong impression.
We are adults, and we can depend on ourselves, giving us his discretion and freedom.
That's right. Okay, so that means the status quo right now, you are dealing with these cases not on a daily basis, but at least frequently, and you know where we stand as a society in as far as execution of wills is concerned, but also the level of conflict that Ugandans find themselves in as a result of either absence or invalid wills being dispensed. Just take us through what you're experiencing as a lawyer.
And Chris, as I mentioned, that the reason we are focusing on this is because of the number of cases that we have seen.
That's right.
Arising from family disputes, but also land disputes. So one of the things is that people do not know how to write wills. So we are going out on Friday, tomorrow, and there are so many programs that have been focused on this to teach people how to write a will. And the first thing that we've been telling them is what is a valid will, that I explained in the first part. But also number two, importantly, what should be contained in a will? What should you put in a will? So what you should put in a will, first of all, the name of the person who we call in law a testator. The person making the will is called a testator. Okay, that should be clear. Who is making this will? Two, the dependents, the spouse, the wife, sorry, the spouse, the children, the dependents, all this should also be clear. Three, the properties, and the properties must be clearly described. If it is land and it is a milo land, please state the block, the plot number, and ABCD. So it must be clearly described. Four, there's what we call an executor. So after you have passed on, who is going to put these wishes into effect? That is the person we call an executor. And therefore you must be able to find a trustworthy person.
That's right.
Who, when you pass on, will not again take advantage of the situation and take advantage of the property. So that is what we call an executor.
Good.
3, 5, witnesses. The will must be witnessed. The witnesses do not have to know what is in the will, but they must be able to see you signing or putting a thumb.
Isn't
if you
that
cannot.
a bone of contention if a witness does not know the contents of the will? How then can they say that is what I witnessed being stated?
Well, you can choose to for them to know, but they don't have to know.
Okay.
Because who is a witness? A witness is a person who can attest to the fact that I actually made the will and saw you sign. So we must make that distinction. So this is the reason we are going out and telling people this is a valid will, these are the contents of the will. Because if you do that, then there will be less wills which are challenged.
Which are challenged, yeah.
Yes.
Okay, just quickly tell us again, hammer it down, when and where this particular initiative will be. You talked of Royal Grounds for Central Region?
Yes. So we have about 8 centers. We have Mbarara, Gulu, Lira, Hoima, Masindi, all the legal aid centers that have Uganda Law Society offices are going to be able to go out. But not just Uganda Law Society staff. We are calling all lawyers.
All lawyers.
All lawyers. Okay. In fact, tomorrow all matters have been adjourned for court to enable lawyers participate in giving back to the community. Okay. In saying that, you know, as lawyers would like to be able to give back. But we're also calling upon all members of the Uganda Law Society. You could be in a WhatsApp group. You know, we have these many WhatsApp groups. Old boys, as many as 40. If you're a lawyer in a WhatsApp group, take some time, 30 minutes off, and just chat on what a will is, how it is drafted, so that you can be able to share.
All right. Bernard Owundo, President of the Uganda Law Society, many thanks for the perspective, and many thanks to you too, Charles Kasibayo, Administrator General, for giving us perspective on succession processes to protecting property rights ahead of Pro Bono Day, which is tomorrow. That will do it for our Take Note discussion, but do stay with us. We'll be right back. We have a lot more to talk about here on Morning at NTV.